Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheela Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilidra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information on this show is not for legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Murthy needs no introduction, but if you need consultation, please log on to murthy.com. From the beginning, Murthy.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The Murthy.com site provides you with latest and cutting-edge information on the US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the PERM certification. We will continue the knowledge session along with the questions for today. And before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello, Ms. Murthy.
Hi, good afternoon or good evening to you in India, I guess, Tharani. And good morning to all the people calling in from India, because I know it's middle of the night and we appreciate having the opportunity to share information both with Sakshi TV and myself and the Murthy Law Firm with each and every one of you that is taking the time, effort and trouble to sign in. So welcome and thank you.
Right. So Ms. Murthy, before we get along with the topic, are there any immigration updates that you want to share with our viewers for this week?
So there's nothing really. I'm trying to think that we are hoping to get the priority dates. The Department of State visa bulletin should be out within a week. So hopefully before next week, we should be able to share any more updates that is happening with the movement of priority dates. There's been nothing alarming or major change that has occurred in the past week that's jumping to my mind. People are starting pre-registrations under the H-1B program. So if you're an employer or an employee, start getting your ducks in a row. It's already November. The pre-registration will start in March. So you need to submit all your information in the next month or two, get your ducks in a row to start filing H-1B packages, PERM and green card, which I believe is what we're going to talk about today. That's a whole separate process, which can take many years to get resolved before you get your permanent residence. And with respect to visa and consulates and appointments, of course, the world has opened up. That's the big change from yesterday, from November the 8th, which means yesterday, Monday, the United States has opened up to allow people from India and other parts of the world, 33 other countries, that are now able to fly directly. So countries like the United Kingdom and other countries that were not having direct flights, all you have to do, of course, is to show that you are fully vaccinated, and they will agree not just to what America agrees to, but certain World Health Organization vaccines are permissible. So people from India who were nervous before about being eligible to qualify are now able to qualify under that. So that's one big latest hot item news that came out in the last 2 or 3 days. And so they will be able to fly into the United States, but they have to show a negative test also in addition to vaccinations within 3 days prior to departure in order to be able to board the flight, enter the United States. And if there's a problem, of course, they would be required to self-quarantine. So hopefully the world's opening up. Hopefully it's a good sign of good things to come. And I know India is expecting its GDP to grow exponentially. So we'll see how all that impacts US immigration. And I believe today one of the latest changes was that people with the OCI card, the Overseas Citizenship of India cards, can apply for medical schools in India. So there must have been a lawsuit preventing them from applying, but that something just came out within the past 24 hours on this issue. So a lot of exciting things going on. Thanksgiving season's around the corner. Diwali just got celebrated, and we talked about Happy Diwali last week, and hopefully that's a big, broad overview of everything that's going on between the United States and India and US immigration and Indian people in India affected by US immigration. Thank you, Tharani.
Right, Ms. Murthy, thank you for the vivid details that you've given us. And before we begin the show, we have a caller on hold, Mr. Eka from Texas. Thank you for calling, Mr. Eka. You may ask Ms. Murthy your question directly.
Yeah, thank you. Hello, Ms. Sheela Murthy. Good afternoon. I have a question regarding H4 dependent status. And I am on H4 visa right now. And 5 months back, I have applied for a H4 extension along with a supplement for my kids. This H4 extension is still pending with USCIS. Meanwhile, I got my H1 and my company has applied for a H4 to H1 change of status. That is also pending with USCIS. And I'm expecting it to get it approved by within next 14 business days. So once I get my H1 visa approved, I will withdraw my pending H4 application with USCIS. That will in turn withdraw the H4 supplement as well. So then I have to apply for a H4 extension for my kid alone separately. So the question that I have is, when I send a H4 extension for my kid separately, should I include any formal letter stating that my situation so-and-so for withdrawing my primary H4 application? Or should I first apply for H4 for my kid online and then withdraw my primary H4 application? So what would you suggest?
Yeah, this one is actually quite tricky because if you're the principal applicant for H4, when you withdraw it, then the child is left out in the cold and in the loop. So you have to, when you do your withdrawal, make it very clear that please do not withdraw the H4 for the child that is attached to my application. And so one option very well could be that you allow your H1 to get approved, let the H4 take 3 months, 6 months, 8 months, whatever. Either make it very clear that you only wish to withdraw your application and not for your child that is dependent for the H4, because if the prior H4 has already expired and there's a gap in status, then the USCIS cannot approve the H4 extension for the child at all. So the other option could be to let the case get processed, let it get even approved, and then you tell the USCIS on the date it is approved, please withdraw my request for H4 and continue the H4 for the child. And if both have gotten an approved, please approve the H4 for the child and only withdraw for the principal applicant because my H1B status is what I prefer to continue with. It's a little bit tricky if your child is depending on your status and that status has already expired in the interim because you didn't answer that particular issue, Eka. Good luck. I hope that was helpful.
Murthy, we have another caller on hold, Mr. Vishnu from Maryland. Thank you for calling, Mr. Vishnu. You may ask Ms. Murthy your question directly.
Hello, Murthy ma'am. Good afternoon. I'm on CPT visa right now. So my employer applied H1B this year. Unfortunately, I have received RFE regarding the maintenance status. The other thing, I have submitted my documents to my employer. He's going to respond. I have a question regarding, initially they filed on change of status petition. Now I would like to request to my employer to make it as a consular process. So I'm traveling, I might travel to India. So the change of status petition can be converted as a consular in pending while RFE is pending, or we can request for the consular process while submitting RFE.
Yes, it's very easy to do that. So that's a simple solution, is somebody who's not maintaining status. If you're traveling abroad, you can say that the applicant, the beneficiary, no longer requires a change of status within the United States because the beneficiary is traveling abroad on such and such date. Accordingly, please issue the H-1B petition approval for consular notification so that the applicant may apply for the H-1 visa stamp at the U.S. consulate in whatever, Hyderabad or Chennai or Mumbai or Delhi or Kolkata, India, whatever, at the earliest opportunity. And then you can book the visa appointment even before traveling, book the interview date if you can get it, if it's opened up. Sometimes we have found that in spite of asking for that, they still give a hard time or they say we cannot approve it, or they say something to give people a hard time. So usually it works, but sometimes we've seen where the USCIS will confirm when they approve the H1 petition that they cannot approve the H1B change of status or extension of status, change of status in your case, because the particular beneficiary has failed to maintain valid legal status in the US. And if that happens, then the 3-year or 10-year bar, the clock starts to tick regarding not just out of status, but also unlawful presence. Because when you're on F1 with D/S or duration of status, you know that the unlawful presence clock does not start ticking, because that's the difference between out of status and unlawful presence, or ULP. And so it only kicks into effect when either an immigration judge finds a status violation or the USCIS finds a status violation, as they may have done by issuance of the RFE or by asking for clarification in a case like yours.
Right. I hope that answered your question. So, Ms. Murthy, we have another caller on hold, Mr. Naga from Los Angeles. Thank you for calling, Naga. You may ask Ms. Murthy your question directly.
Yeah, hi. Good afternoon. Good afternoon, everyone. My name is Naga. I have a question regarding I94 expiration. So my wife is on is a H4 dependent visa, but her I94 expired recently, 10 days prior to be precise. She had a valid passport and visa, but they cut short her I94 by 3 months for some reason. So when I was trying to file for my H1 extension, we have noticed this thing, and we have brought it up to the attorney. So I wanted to know what are the implications, and what are the best options available as of now to me. Can you please guide us?
So Naga, this happens all the time. This happens because it's not by mistake or whatever. In 99% of the cases, it is because your wife's passport was expiring within 6 months. And by law, because of reciprocity between the United States and India, the government of India and the government of the US, the CBP, the US Customs and Border Protection, the CBP is only allowed to grant her the I-94 valid until the date of her passport validity. And people don't realize, because they don't check carefully the I-94 expiration date, which by the way is very, very important, Naga, for everyone to check their I-94 expiration when they enter, because that's the only basis on which you're legally allowed to stay in the US, is your latest I-94 card date. So when she enters and they give her the shorter duration, she's either supposed to fly an extension, file the extension with the USCIS before it expires, or travel abroad and come back with a new passport that is extended, so she gets a full I-94 date, which matches with your H-1B approval notice date. But now if the milk is already spilled and the date is already passed and it's 10 days later, you could potentially use the original I-94 approval with her H-4 and file the extension and point out to the USCIS that her latest H-4 validity is until the same H-1B validity date as yours, and not the shortened, what we call truncated validity based on a shortened passport. There are old ELA liaison notes from back in 2001, so over 20 years ago, issued by a senior representatives of the USCIS, along with the American Immigration Lawyers Association, or AILA, where the USCIS confirmed that the person who has a truncated I-94 isn't automatically deemed to be in violation of status, either unlawfully present or even out of status, because the person has another valid I-94 card showing the full validity and that it has not yet expired. So you could potentially use that in order to file the H-4 extension with the USCIS. Sometimes USCIS, Naga, will push back, give a hard time and say, I'm sorry, the latest I-94 shows that her status expired. She has now triggered the 3-year and 10-year bars. She needs to depart before 180 days, and they may refuse to grant her the H-1B or the H4 extension, even when they approve your H1B extension of status. I have heard from a couple of very recent people just from the last 1 week that when they are doing the premium processing and filing the H1 extension for the principal, the USCIS is sometimes approving the H4 extension, even though under the Trump administration they had bifurcated or separated the two processes. They are now doing occasionally, not all the time, the two, and approving the H4 as well under the premium processing. So if you, when you file it, take the position that use her original I94, which was not expired, mention that as the expiration date, because that is her correct expiration date, because she's allowed to stay here, even though the latest I94 card, based on her latest entry, was based on the passport expiration date. So it is not an error of CBP. Use that, try to make that argument. If it doesn't work, it's less than 180 days, let her leave the country before 180 days and simply apply for the H4 visa based on your H1B petition approval, so that she avoids triggering a 3-year bar and a black mark against her status, Naga. I hope this information was helpful. Thank you.
Right. So, Ms. Murthy, we have another caller on hold, Mr. Konda from Arkansas. Thank you for calling, Mr. Konda. You may ask Ms. Murthy your question directly.
Yeah, thank you. Hi, Ms. Murthy. Thanks for my call. My question is, filed I-485 last year in October 2023. My priority date is 2014. So recently I got 485 application by requesting by FOIA. So what I found that one of the phase, right, fifth phase was missing whenever my attorney 485. So what are the chances to it, or they are going to?
Yeah, your voice is breaking up. I'm not
Yeah.
sure if we heard everything, but if the long and short of it is that when the 485 was filed, there was one page missing out of the 20 pages on the new 485 form. Page 5 was missing in your case. Sometimes the USCIS may think that they misplaced it and they lost it, or it could be that the lawyer and the lawyer's team, the law firm messed up, or somebody along the way dropped a page. So if they issue an RFE, you can respond to the RFE and say, here is the page that is missing. It was filed properly. We don't know why the USCIS may have misplaced it. Or if they issue an RFE or a denial, if they issue a notice of intention to deny, you can submit that one page. Now, generally, they don't deny. They may ask for it. They may not know. It depends on how important that page is for their approval of the package. They very well could issue an RFE saying this page is missing. Please provide it to us. Hopefully, that's the best case scenario. Worst case scenario, if they issue a notice of intention to deny, you can respond with providing that missing page. And hopefully that should take care of the problem.
Right. Our next caller, Ms. Murthy, is Mr. Anil from New Jersey. Thank you for calling, Anil. You may ask Ms. Murthy your question directly.
Yeah, thank you. Thank you for taking the call. So here is my question. I have downgraded my application last year in October from EB to EB with fresh I-140 and it got approved, and I have my EAD with AP. And the thing is, it's been 180 days over. It's 1 year over. Now, since the dates went back, I was thinking of changing the job to take a full time with the. So now the question I have is, I need to file 485 days. So there, I have to provide a source code, where my official standard occupational classification. So when my firm was filed around 9 years ago, it was being given as code, given as software developer application. So now my designation is slightly higher than that. Maybe I may be getting into the software side. So it may not be the same code. That company may give a different code as their standards that they are offering to me. But these are all in the same software development side. So technology side. So I'm just thinking if I file this 485J with a different SOC code, is there any issue? And because I'm switching non-immigration status to this particular EAD state, pending adjustment of status. So I just want to take your opinion.
So Anil, I'm having this, I don't know if there's a problem with all of your computers, but a couple of you, most of your words, half your words or more are breaking up. But I think I understood the question or the issue that you were raising is that the SOC code is different. You want to file a supplement J and you're a little concerned what could happen. So it depends on the job duties, right? USCIS primarily considers the job duties itself. The SOC code and the codes are helpful, but they're not the sole determining factor, Anil. The main issue always is the job duties, the job description. And if in 9 years there's been a natural progression in the job duties and you can show that in fact it is the same or similar job, hopefully the case should get approved. I've heard of very, very few denials by USCIS with supplement J filings where there's been a denial based on the job duties not being considered same or similar. But generally those are when there's a big age, there's a big difference between the actual duties of the person. And the examples I think we've given is where somebody was a software programmer, or an analyst, or a software engineer, program manager, and then suddenly becomes, for example, a professor of software engineering. Even though they're using the same knowledge, they consider that that potentially is not the exact same job or same job duties. In another case, somebody changed to something completely different. So of course they deny, but majority of the cases, we haven't found a problem. So if it's purely only a SOC code in your particular case, Anil, hopefully that should not be a reason for denial. Even in the prior administration with the Trump administration, going after people, giving them a hard time, denying cases, I'm hoping that your particular case should not have a problem as long as the job duties continue to be same or similar.
Right. I hope that answered your question, Anil. So, Ms. Murthy, shall we move on to our today's topic, the PERM certification?
Sure. If it sounds like people are desperate for questions and need guidance, and we have, 5 minutes left or so, 10 minutes.
Right.
Sure.
Right. So, Ms. Murthy, could you please tell us what a PERM certification is and how a person can file it?
Okay, so I mean, the process. It's like saying, well, what does surgery mean? What does brain surgery mean? And how do I do it? I mean, there are books and books and books and thousands of pages with case law and what it means and how the process works. But in short, as many of you might already know, or if not, PERM is the first stage in the 3 stages, primary, most important stages for filing a green card in an employment-based case where labor certification is required. What is PERM? PERM is a permanent electronic review management. It is the technological, supposedly fast version of filing for labor certification compared to the olden days where you filed the labor certification and waited several months or years, both for the H-1 LCA to get approved and for the green card PERM to get approved. Now it's all done electronically, and so the process is supposed to be much faster and smoother. What is the employer establishing in stage 1? The employer is showing the U.S. Department of Labor that I tried to find a candidate, a U.S. worker, a U.S. citizen, permanent resident, qualified person with EAD in the U.S. to perform the job duties that my company needs, but I was unable to find a person with these specific skill sets because there is a huge gap. There is a huge demand. The supply of people is very, very short in compared to the demand for people in the STEM fields in general. So that's how you basically go over and explain the entire, that's what you're showing, that there's no ready, available, and qualified U.S. worker to perform the job duties for that employer in that specific job that is being performed by the employee. Now, if a company has many, many employees, you don't want to show that for this person I need this and that person I need that. So it's very important to show what are your standard, what they call standard criteria, so that it is not called unduly restrictive job requirements, saying, well, I need this person to have a master's degree or 5 or 10 years of experience because the government says that much experience is not required for a programmer analyst, for example. There was a recent case that might be of interest to many people who are trying to understand this. So till now, we had everything being done by, as you know, electronically, and we also had everything that was being done by following paper filings and paper responses and responding to employees who applied by paper. But the USCIS is now saying that, sorry, that won't work anymore. Department of Labor and USCIS, particularly in the I-140 stage, and US Department of Labor, in the case, the judge said it has to be what exactly is in real life by the employer. So if in the real life, the employer is responding to people by email, then you should reply to people by email, not by snail mail letter, which with post office delays may never reach the person or take weeks or months to reach. So you can no longer rely on the old case law that we have all been relying for decades and decades, because now the USCIS is basically saying, and Department of Labor, you have to follow all these, dot all the I's and cross all the T's and do these 400 other things. Plus, we want you to follow the method that you would in real life, were it a legitimate person applying to your company for a job.
Right, right. So, Ms. Murthy, what kind of audits can one expect from the PERM?
There are audits of all kinds. There's a Department of Labor audit based on the job being unduly restrictive with too many requirements, whether the employer truly did a bona fide legitimate search for the candidate and dotted the I's, crossed the T's, followed the timeframes, whether the newspaper advertisements ran those 2 particular Sundays, whether the candidates who applied for the job were properly denied based on lawful job-related reasons as acknowledged and available according to Department of Labor laws and regulations and case law on this topic. So an audit can be, and salary, of course, the prevailing wage. If you don't pay the prevailing wage but rely on an alternative wage survey, the Department of Labor can come back and say, we don't agree with this wage survey. So there's 100 reasons why the PERM can be denied. So it's very important to understand it. PERM, by the way, is probably the most difficult, complex, nuanced part of any green card process. So it's very important to follow the process very, very carefully and monitor what's happening with case law.
Right. Right. So, Ms. Murthy, going to the next question, how can a pending application filed under the PERM be withdrawn?
Just send a letter to withdraw it with the USCIS. Just notify the Department of Labor to say we are not withdrawing this particular application. The employee is no longer working in our company, or whatever the reason that you're giving, or just say we wish to withdraw this application. Sometimes they don't send a confirmation, and sometimes they do, but if they don't, if you have proof under the British mailbox rule, English common law, which applies in America also, if you can show proof that you filed it, especially if you have confirmation of the delivery like FedEx or US Post Office or whatever, or confirmation of the delivery, you can then protect yourself saying we withdrew it on this date. You can't issue a denial on this basis or whatever.
Right. So, Ms. Murthy, with that, we come to the end of our show, and I request you to please give us and our viewers the golden immigration message for this week.
Okay, so golden immigration message. I'm looking out, it's fall, the colors are changing, the leaves are looking beautiful, and there's a lot of leaves that have fallen and a lot of leaves that are bright red and bright yellow outside here in Maryland. So all I can say is, life, we always talk about every black cloud as a silver lining. Even the most beautiful trees lose their leaves. They are sad, they lose their leaves, but there's always light at the end of a dark tunnel. There's always hope when spring comes around. And this is nature's way of continuing. So problems, challenges, and difficulties are not there to stress us out, to give us heart attacks, high blood pressure, or get gray hair. All of this is simply to make us smarter, wiser, better as human beings, better as spiritual beings, better to learn, to become stronger and wiser, so that we can become truly loving, caring, good human beings along life's journey, helping other people in life. And I know Thanksgiving is later this month, and the whole idea of Thanksgiving is to have gratitude and thankfulness for everything, including the problems in life, because the bad days make us appreciate the good days in our lives. Thank you as always for this opportunity.
Right. Ms. Murthy, we sincerely and supremely admire the takeaways that you give us. And like always, it's a privilege hosting you. We hope you have a good day.
You too. Thank you so much.
Thank you, Ms. Murthy. You're watching Sakshi TV Live with me, Torini Makana. Thank you.